Good morning and welcome back to my channel. My name is Joanne. I'm a law student from Melbourne, Australia. I have woken up to seeing there was a judgment in place. See, look, my hair, and it happens to occur on a day that I have nothing else to do. I do have a doctor calling me hour, so I've got an hour. Otherwise, I'll have to put you on hold, take the call from the doctor, and come back. Yes, it does sound interesting, doesn't it? I also need to thank the WAOACB Discord because they've actually broken down some of the stuff for me as well. So we will be able to look at a lot of the screenshots, particularly of this. So I haven't actually read it. Hello, number one fan. Hello, Plan to Create. Hello, Bella. Hello, everybody. So what I have ascertained from what I have seen is that there will be a trial. That this it hasn't gone both ways. It hasn't gone the way of either party. However, there are some really serious allegations, and the court has ruled that there could be intentional tortious interference. It has ruled on a couple of things that a jury needs to decide on. So let's just have a look, and I'm just going to share the screen. So I'll go through it. You're going to get my live reaction. I haven't read it. We're going to read it together. There's 18 pages. As I said, I do have to take a phone call in this. I did think about waiting, but I thought, no, let's get this going. And thank you to the people in the Discord and for Miss Balls on Twitter. They're the people that alerted, that I read it about. So this now, let me just tell you that everything stated in a judgment can be quoted and considered as a fact, okay, and can be therefore quoted. So we can now say in the decision paragraph such and such, Her Honour stated this, and I've had a quick scroll through, and she actually talks about the facts. So she talks about facts, and where she talks about facts, they are facts that the court have determined. Okay, and so we'll find out whether she has deemed. Let's see what this says. And I'm sorry, I'm not very well. I'm a bit under the weather. So the above matter came for hearing before the Honourable Carrie Willis on the 6th of January 2025, and the party's motion for summary judgment. Amber Stavik appeared on the behalf of plaintiffs. Jennifer Moore appeared on behalf of the defendants. Plaintiffs filed exhibits 100 to 125, and defendant filed exhibits 200 to 285 through the Minnesota Digital Exhibit System. So what she does at the moment is it gives a summary of what's just happened, and then you see findings of fact. Where she talks about findings of facts, they are facts. They are not we can't dispute those. The court has found that these are facts. The plaintiff amended complaint contains 85 statements upon which their case is based, and after oral argument was concluded on the parties' motions, the court created a document numbering and provided copies to the parties. On March 26, 2025, plaintiffs filed a document that matched the court's document and included links for each statement. And it says, see Exhibit 1 attached. Similarly, defendants filed separate exhibits containing a link for each of the plaintiffs, to the copy. On the 26th of 2025, plaintiffs filed a document that matched the court's document and included links for each statement. Now it says, some of the plaintiffs' links were missing or did not work. The court has identified the statements that did not have supporting links in this order. Now, from what I can work out, the court has essentially sort of taken out the ones that didn't work out. So they're not going to make a decision on the links that don't work. That is my first impression. As again, I could be wrong, but this is just what I've had a look from a quick thing. Based on the files, records, and proceedings herein, the arguments of counsel, the review of exhibits, and the parties' memoranda to the court makes the following. So here, the judge has said, these are what I've used to make my decision. Okay? The files, the records, the proceedings, to date, the arguments of counsel, the review of exhibits, and so based on everything that has been filed in the court of this matter, okay? So she doesn't care that Robert Shin has, what's been filed in the Shin case as such. She's only basing it on what has been filed before her, okay? That's really important to remember. Now we've got finding of facts. Now these are facts, okay? On the 31st of March 2022, Plaintiff 7M Inc. and Robert Shin, which are a talent management company, and its CEO and sole owner, respectively, based in the state of California, commenced this lawsuit against Catherine Polston and Without a Crystal Ball LLC, a Minnesota resident and Minnesota corporation, respectively. Facts, okay? Facts. Now, interestingly, she put talent management company in inverted commas, but a fact, okay? Fact. Ms. Polston runs several social media accounts with substantial reach, numbering in the tens or hundreds of thousands of followers, and the attendant engagement, particularly on Instagram and YouTube. Fact. Shortly thereafter, the complaint was amended to add Miranda Derrick and James Derrick as plaintiff. Fact, okay? These are facts. The amended complaint played 9 causes of action. The 9th count is mislabeled as count 10. The amended complaint skips from count 8 to 10 against Ms. Polston and her LLC, but counts 1 and 2, defamation and defamation per se, respectively, ultimately underline the remaining counts. Plaintiff alleged that Ms. Polston, via her Instagram page and other social media, defamed the plaintiffs by posting false statements about 7M and associated individuals. The remaining counts are for tortious interference of contract, count 3, commercial defamation, count 4, and intentional infliction of emotional distress, count 5, negligence per se, count 6, deceptive trade practices, count 7, and intentional interference with prospective advantage, 8, and injunctive relief, count 10. So we've got a footnote down here. At the motion hearing, plaintiffs advised they were no longer pursuing a claim for intentional infliction of emotional distress. Okay. So they're not making that claim anymore. They've decided to drop that. Plaintiff's business is in the field of social media communications and marketing, as well as brokering deals between performers, particularly dancers and commercial venues. Defendant, in her social media posts, as listed by plaintiff, claims that plaintiffs, in addition to their commercial ventures, are involved with Shekinah Church, which the plaintiff claims that defendant characterizes as a cult. Defendant also made allegations that plaintiff and other dancers have little or no control over their content, living arrangements, or finances. Plaintiffs argue that all of the defendant's claims are false and have resulted in plaintiff's reputation and standing in the community being irreparably harmed. Now, would you consider, so she's put that in her fact finding, she's declared that as fact, okay? In his deposition, Robert Shin, now we don't know what was in the depositions, okay? But she's going to refer to depositions here. Robert Shin testified that the spiritual meaning behind 7M is that God created the heavens and the earth in 7 days, and it is not associated with the 7 mountains of influence, as suggested by defendant. Mr. Shin also testified that 7M does not provide dancers' wardrobes and that not all dancers are members of Shekinah Church. Oh dear. Yes, that's what we've said, right? Anyway, okay. And that's what we said, that not all dance members of Shekinah Church and not all Shekinah Church members are in 7M. We knew that. Hello, everybody that's joining. Sarah and Carol and Flying Mum and Michelle and anybody else I may have missed, okay? Additionally, he indicated that 7M does not impose consequences if church members miss church, and that no one from Shekinah Church writes checks for dancers from their personal accounts, and that he's unaware of anyone from 7M writing checks for dancers' personal accounts. He denies that the dancers are living under a tight control and are forbidden to do anything without the permission of him or one of his associates. He also claimed he never made any suggestion to dancers regarding the 10-10-10 arrangement, 10% tithing, 10% offering, 10% to man of God. He further testified that he believes there is evidence of defendant contacting 7M sponsors, including Forever 21, and advising that 7M is a cult and they should not work with 7M. Mr. Shin claims that the dancers have left 7M because of the defamation and hostility created by the defendant and her followers, and that 7M has suffered financial losses due to their departure. Now, isn't that very interesting? That's a completely different explanation compared to what Katie told us that his deposition was about. Okay, so anyway, we're up to point 5. This is, as I said, I'm trying to do this quickly because I've got to take a phone call. I've got a phone call coming through that I will have to take, so I might have to put on some mood music and give you a tea break while I take the phone call. So yes, I have an urgent call that I'm waiting for, but anyway, we'll keep going. In her deposition, Miranda Derrick testified that the defendant had interfered with her business by reaching out to brands with which Miss Derrick was collaborating and telling not to associate or work with Miss Derrick. Miss Derrick claims that the defendant has falsely stated that Miss Derrick is a victim, that she does not run her own financial accounts, and that she gives all of her money to her pastor and church, that she does not speak to her family and only wears gifted clothes, and she's associated with a cult. Miss Derrick indicated that no one at 7M or Shekinah Church has ever asked her to sign blank checks. She claimed she provides her own wardrobe and that Mr. Shin only made recommendations about music. Miss Derrick maintained that she has consistently lost income and brand collaborations since the defendant began covering the plaintiffs, including Sutter Home Wine, Stronger, Keto, an athletic company, and a travel company. In his deposition, James Derrick stated that Miss Paulson interfered with a brand contract the plaintiffs had with the Clippers. He has earned less since defendants started reporting on him. In her deposition, Miss Paulson testified that she has a YouTube channel, a Facebook page, Instagram, Threads, TikTok, and Twitter. She said she believes the Derricks are lying about not being controlled by the Shins via 7M because they appeared incredibly coached. Miss Paulson stated that she based her accusations against Mr. Shin and 7M regarding financial control and SA based on the testimony of individuals influenced and harmed by Mr. Shin. However, she was unable to point to any specific testimony. Miss Paulson explained that she based her reporting on Miss Derrick being taken advantage on information provided by other individuals. She further indicated that at the time she reported that the Derricks were not married, she didn't know if they were married or not. Miss Paulson stated that she has encouraged people to boycott the plaintiff and their social media and has shared information regarding companies. She just didn't admit to that, did she? Miss Paulson stated that she has encouraged people to boycott plaintiff and their social media. And she has shared information regarding companies who cancelled with the contracts with the plaintiff. Miss Paulson stated that she based her reports on Mr. Shin, 7M, and Shekinah Church groomed individuals based on public statements made by other people. Did she really admit? Did she really make that admission? Did she really admit that? She has admitted to interfering. Has she admitted to tortious interference? Plaintiff's amended complaint contains 85 statements that they describe as false allegations to support their claims. Some of the statements either do not have links or contain a statement that post's been removed. See statements 12, 21, 31. So, seeing as the court was not able to independently review those posts, it cannot be said whether or not there is a genuine. Read admission again. Miss Paulson stated that she has encouraged people to boycott the plaintiffs and their social media. She stated she has encouraged people to boycott the plaintiff and social media, and she has shared information regarding companies who cancelled their contracts with the plaintiffs. Wow. Okay, that's a highlight. So it says, since the court was not able to independently review these posts, it cannot be said whether or not there is a genuine issue of material fact as to whether they are defamatory, it is appropriate to grant defendant's motion for summary judgment in regards to those statements. So the ones that they can't verify, they've dismissed. Okay? Only to those statements. In several of Ms. Paulson's posts regarding plaintiffs, she includes hashtags such as cults, free Miranda, 7 mountains of influence, free Miranda Derek, trafficking, forced labor, true crime, facts, false prophets everywhere, false prophet Muhammad, human trafficking and sex trafficking. All these hashtags were made reference to all or one of the plaintiffs. And she's labeled all the statements. In one of her posts, Ms. Paulson stated that 7M is likely associated with the 7 mountains of influence, which she describes as a damaging and anti-biblical movement that has taken a hold of Pentecostal churches. Mr. Shin stated in his deposition that 7M is not related to the 7 mountains of influence. Many of the defendants' posts mention that Ms. Derrick has been lured into a church that tightly controls their members, and that Ms. Derrick has been groomed, abducted, and brainwashed. Several of the posts also characterize Ms. Derrick and Mr. Derrick as victims of 7M. Claim Ms. Derrick does not have a car or home registered in her name, and state Mr. Shin and other associates of 7M are forcing her to have little or no contact with her family. These statements. So she's listed the statements. Ms. Derrick denied all of these claims in her deposition. Ms. Paulson reached out to MAC Cosmetics to determine if they had a branding deal with Ms. Derrick and to inform them that it appeared Ms. Derrick was falsely advertising that she was working with MAC Cosmetics. Additionally, Ms. Paulson took a screenshot of Mr. Derrick's Instagram story where he tagged Forever 21 for advertising purposes. Ms. Paulson posted the screenshot to her Instagram account with the text over Mr. Derrick's page saying, "Internet, do your thing." The link to this allegation in the complaint can be found in Exhibit 117. It worked. Ms. Paulson's other captions and reels refer to 7M luring dancers with unfulfilled promises, forcing dancers to isolate from their families, ostracizing dancers who refuse to submit to the church agenda, and holding the dancers captive. The posts also contain various statements that 7M is controlling dancers' schedules, times, activities, wardrobe, music, body weights, and finances. She additionally claims that the dancers' social media is controlled, curated, and fake, and that dancers are constantly and forcibly worked by 7M for the sole benefit of Mr. Shin and his associates. And then all the statements there. In addition to her captions, Ms. Paulson recorded several Instagram live videos in which she states that 7M is luring the dancers and lightly engaging in human trafficking, that Ms. Derrick is not allowed to speak to anyone or be left alone, does not drive, and that dancers are highly monitored by management and isolated from their friends and families. She compared 7M to a Jim Jones cult and accused 7M of human trafficking and forced labor. In both her live reels and her Instagram captions, she characterized 7M as predatory and stated that dancers are not getting paid for a fair wage and in a cycle of being trapped in a cult where every aspect of their life is dictated and controlled. Ms. Paulson called into question Derrick's marriage and stated she thinks that all the dancers' marriages are fake. The Derricks are in fact married. The defendants also claim 7M deleted Derrick's Facebook profile and Mr. Derrick's Twitter, or Mr. and Mrs. Derrick state that they have control over their own social media accounts. So again, where there's been links, they've said where you can find them. You're saying some journalists, Michelle? Okay. Ms. Paulson stated that 7M is preying and exploiting black dancers and making black dancers believe everyone is mad at them because they were black. Ms. Paulson posted about contacting the LA Clippers regarding information she said she discovered about 7M, and she claimed a victory when 7M and indefinitely cancelled by the Clippers. Ms. Paulson stated that Mr. Shin is using the church to sell non-profit, to defraud people, and to enrich by funneling donations to shell not for-profit companies, which compared to money laundering scheme. Now, because that statement about, so we're up to page 7, because that statement appeared in a judgment, okay, Ms. Paulson stated that she has encouraged, and it's appeared under the thing of findings of fact. We can actually come to the conclusion that she has been into. You can draw the conclusion that the court has stated she has contacted sponsors, because it's appeared under the fact finding. It's appeared under fact, and she has admitted, she admitted that. Now we're getting to the law. Okay, this is where we get to the conclusions of law. A party may move for summary judgment identifying each claim or defense or part of each claim or defense on which summary judgment is sought. Okay. So, well, I'll just pause there. So we've had the summary of what's happened. Then we've had the findings of fact, what the judge has what the evidence has shown, the facts of the case. Now we're going to look at what the law says, and then we get to the final judgment. We get to the final decision and explanation, and that's how it works. You have your summary, your fact finding, all your findings of fact. Now we're going to go through the law, and then we're going to get to the decision and possibly how she's come to that conclusion. Summary judgment shall be evident if the movement shows there's no genuine issue as to material fact and that the movement is entitled to a judgment as a matter of law. So I'll just point out that where they have won their summary judgment are only because there was the links did not work. So the court has said, because we cannot verify that those claims were made because the links aren't working, we can't test them. So we're just going to dismiss them. So that's the only part of the only win Katie Joy has, is that there was no evidence to show that they came out of her mouth, essentially, because the links don't work or she's deleted them or something like that. But, however, everything else has been denied. A party asserting there is no genuine issue as to material fact may support the assertion by citing to particular parts of materials in the record, including depositions, documents, electronically stored information, affidavits, stipulations, including those made for purposes of the motion, admissions, interrogatory answers, and other materials, or showing that the materials cited do not establish the absence or presence of a genuine issue for trial, or that an adverse party cannot produce evidence to support the fact. And that's what they've got. They've not been able to prove it, okay? They've not been able to support evidence where all the other evidence the judge has looked at. When reviewing a motion for summary judgment, the court must view all the facts in the light most favourable to the non-moving party and construe all inferences against the moving party. So there's case law now. A court deciding a summary judgment motion must not make factual findings or otherwise weigh the evidence. The district court determines whether a genuine factual issue exists. A genuine issue is one that the parties reasonably dispute. A material fact is one of such nature as will affect the result or the outcome of the case, depending on its resolution. When the moving party has carried its burden, the non-moving party must do more than simply show there is a metaphysical doubt as to the material facts. The non-moving party must offer significant probative evidence tending to support its position. If there is any doubt to the existence of a genuine issue of material fact, the doubt must be resolved in the favour of finding a fact issue exists. In considering a motion for summary judgment, the inquiry is whether there is any genuine issue of material fact, not how any such issue should be resolved. Now, she's going through all the counts. So that's what the law states. So for there to be, she has to show, to come to the decision, she has to, the court, the law says that there's a certain steps. So now she's going to explain it. The elements of defamation require the plaintiff to prove that defamatory statement was communicated to someone other than the plaintiff. The statement is false. The statement tends to harm the plaintiff's reputation and to lower the plaintiff in the estimation of the community. And the recipient of the false statement reasonably understands it to refer to a specific individual. Again, lots of case law. The truth is an absolute defence to a defamation action, and true statements, however, disparaging and not actionable. That is true. As a general rule, the truth or falsity of the statement is a question for the jury. Statements of pure opinion are protected under the First Amendment. Whether a defamatory meaning is conveyed is dependent upon how the ordinary person understands the language used in the light of surrounding circumstances. In deciding whether the words bear a non-actionable meaning, the words must be construed as a whole without taking any word or phrase out of context or placing undue emphasis on any part. Again, we've got more here. Epithets or adjectives can constitute defamation if they imply a specific type of reprehensible conduct. If the plaintiff is a public figure, the plaintiff must prove that the defendant acted with actual malice. Actual malice is shown only by proof of defendant's actual knowledge of falsity or reckless disregard of truth or falsity of his publication. Reckless disregard for truth is a subjective standard. The Supreme Court held the following in regard summary judgment and the actual malice standard, where the New York Times clear and convincing evidence requirement applies. The trial judge's summary judgment inquiry as to whether a genuine issue exists will be whether the evidence presented is such that the jury applying the evidentiary standard could reasonably find for either the plaintiff or the defendant. Thus, where the factual dispute concerns actual malice, the appropriate summary judgment question will be whether the evidence in the record could reasonably support a jury finding either that the plaintiff has shown actual malice by clear and convincing evidence or the plaintiff has not. While the plaintiffs do not address whether they or not they are public figures, they seem to concede that the actual malice standard applies to this case because they argue that they have satisfied the actual malice standard in their pleadings and make no mention of common law malice. Turning to the elements of defamation, the first element is satisfied as the plaintiffs have proven the statements were communicated to someone other than the plaintiff. Defendant undisputedly made the statements at issue on a social media platform that was disseminated to a significant number of people other than the plaintiff. Second, there are several disputed facts regarding the statements were false or made by the defendant with reckless disregard of their truth or falsity. In the depositions of Mr. Shin, Mr. Derrick, and Mrs. Derrick, they dispute all of the statements made by Miss Paulson in her various posts, including the meaning of 7M, the amount of control exerted by 7M and Mr. Shin over the Derricks and other dancers, and that Mr. Shin and 7M were engaged in forced labour and trafficking. The truth or falsity of those statements is a question for the jury. Miss Paulson argues that the statements made by her regarding the plaintiffs are her opinion and therefore should not qualify as defamation. However, the court carefully reviewed all of the plaintiff's videos and captions and does not find that they are all rooted in opinion. While Miss Paulson occasionally claims in her posts that the information provided in her posts are her opinion or based on other people's allegations, she usually follows up these posts with hashtags referring to trafficking, human trafficking, sex trafficking cults, and forced labour. These posts must be construed as a whole. Not that I have seen number one fan. I don't believe the judge has made a finding as yet. When looking at each post as a whole, a reasonable could find that Miss Paulson acted with actual malice. Malice, actual malice. There we go. Miss Paulson that argues that her statements referring to 7M are as a cult are protected under the ecclesiastical abstention doctrine, which provides doctrinal statements as to whether a church is a cult. However, Shekinah Church is not a party to this proceeding. In this case, Miss Paulson is referring to 7M being a cult, and such statements will not be protected under the ecclesiastical abstention doctrine. Furthermore, a reasonable jury could find that describing 7M as a cult could imply specific type of reprehensible conduct. Third, the people she relied on were former members who had unsuccessfully, well, that's right. Third, a genuine issue of fact also exists as to whether these allegations could harm the plaintiff's reputation. in the community and lower the estimation of the community. Presumably, a reasonable jury could determine that accusations of forced labour, human trafficking, and cult-like behaviour could harm one's reputation and the estimation in the community. Fourth, it is undisputed that all of Ms. Paulson's posts clearly refer to one or more plaintiffs, either by her direct statement or hashtags included in her posts. It's undisputed. Because a genuine issue of material fact exists as to whether Ms. Paulson acted with actual malice. As such, summary judgment is not appropriate on count 1. Wow, there is a lot there. There's a lot there. There's a lot to take in that actual argument. And it's interesting because some of the stuff that the judge has said is stuff that we have said all along, that Shekinah is not a party to it. And therefore, everything that she's saying is 7M, and 7M is a talent management company. So now we get on to the second one. I don't know who she relied on, and I think it said in the fact-finding part that she wouldn't elaborate as to where she got the information from. So, all right. Hey, I think by the time I get my phone call from the doctor, we're gonna need a break, eh? Because there was a lot in that. There was a lot in that. I mean, I've highlighted some of the main points, but yeah. Her hashtags, it could be her undoing. Okay. Yeah, I'm sorry that it's late for some of you. It's like 10:15 in the morning here. And we're the dumb ones because we figured it out and then yes. But yes, I just thought I'd come on quickly and try and sort this out. But as I keep saying, I'm only a law student. I only study the law. I have no idea, like, where and you know, I always say to you that you can I've just had some tests done. I'm just waiting for my test results, Michelle. Something that was picked up. I had to have some tests after they picked something up in the medical trial I've been having, and they just said go get checked out. So, but I'm a bit underwhelmed. So again, I'm just interpreting it in the eyes of a law student here. Okay, so defamation per se. Damages are presumed in cases of defamation per se. Courts allow presumed damages because statements that are defamatory per se are virtually certain to cause certain injury to reputation. And this kind of injury is extremely difficult to prove. Courts have recognized statements such as false accusations of committing a crime and false statements about a person's business, trade, or professional conduct to qualify as defamation per se. She could be done. So she could literally be done for defamation per se. Okay. However, damages cannot be presumed, and a showing of actual harm to reputation is required where defamatory statements were made by the media involved a matter of public concern and that there have been allegations of actual malice. Oh, we're going to find out. We're going to find out whether she's a journalist. The determination of whether speech involves a matter of public or private concern is based on the totality of the circumstances, and the courts should consider the content, form, and context of speech. While the media versus non-media defendant distinction is not in and of itself determinative as to whether a private defamation plaintiff may establish actual harm to reputation in Minnesota, the distinction may have relevance in analysing whether the challenged statements involved a matter of public concern. Speech deals with matters of public concern where speech relates to a subject of legitimate news interest. Accordingly, courts may consider dissemination of statements in the news media as one of the many relevant factors in determining whether the statements involve a matter of public concern. The courts find that Miss Paulson's statements regarding the plaintiff were a matter of public concern. Oh, gee whiz. As there were legitimate news interests in the plaintiffs. There was significant media coverage involving the plaintiffs, including Netflix documentary and other articles in publications such as Rolling Stones and New York Post. The court finds that there is a genuine issue of material fact whether Ms. Paulson acted with actual malice in making her statements as discussed in Court 1. Because there is disputed issue of material fact regarding whether Ms. Paulson actually acted with actual malice, damages cannot be presumed at this stage. So summary judgment can't be granted. So if they find on, so if what they're saying is that if she's found guilty, if the jury finds count 1, then likely there'll be count 2. Yes, we get a jury, Cheryl. There's a jury. I think we might have to do some fundraising so I can attend. Hey, would you like to have learner lawyer Joe sitting in the court? Tortious interference of contract. The elements of wrongful interference with contractual contract are the existence of a contract, the alleged wrongdoer's knowledge of the contract, intentional procurement of its breach without justification, and damages. Ordinarily, whether interference is justified is an issue of fact, and the test is what is reasonable conduct under the circumstances. First, plaintiffs testified that they had sponsorships and or contracts with such companies such as Sutter Home Wines, Stronger Keto, Forever 21, and LA Clippers. Secondly, clearly Ms. Paulson knew of these contracts as some of her posts referred to plaintiffs' involvement with Sutter Homes. Oh, here we go. Ms. Paulson knew of the contracts as some of her posts refer to plaintiffs' involvement with Sutter Home Wine, Forever 21, and the LA Clippers. So Ms. Paulson intentionally posted content which referred to her contacting the Clippers regarding plaintiffs, and other posts where she stated, "Internet, do your thing," regarding the plaintiff's partnership with Forever 21. Ms. Derrick also testified that she was aware that Ms. Paulson contacted brands with whom Ms. Derrick worked. Now, notice that Her Honour has used the word intentionally there. Intentionally. She has intentionally. Fourth, whether Ms. Paulson's alleged interference was justified is a factual issue to be decided by the jury. Fifth, plaintiffs stated that they have suffered loss of income since defendant allegedly interfered with their contracts, and so there's no summary judgment on that. But yes, so it's for the jury to decide. The court has said that she has admitted. Remember, in the facts, it had stated that she had admitted to contacting them. Right, so there we go. What about the threats? Could there be, I'm not sure whether there could be a criminal. I guess that would be up to 7M to decide whether they want to pursue that or not. Okay. Commercial defamation. If the defamation affects the plaintiff in his business, trade, profession, office, or calling, is defamation per se and thus actionable without any proof of actual damages. Again, you'll notice, yes, and that's the judge's word. And as I said, Michelle, if it's in a judgment and the judge has written it, generally it is like the gospel. It is the gospel according to Kari Willis. The Honourable Kari Willis. Because as I said, she said that she's looked at everything and watched all the videos to make that determination. So, and I wonder if the judge has watched more videos than her actual lawyers. A jury could reasonably conclude that the alleged defamation did affect the plaintiff's business, trade, profession, office, or calling. For example, Mr. Shin testified in his deposition that 7M is now defunct and has no clients. Similarly, both Miss Derrick and Mr. Derrick testified that they earned less income and gained less sponsors incrementally as the defendant began posting about the plaintiffs. Because count 1 and 2 underlie plaintiff's commercial defamation claim, and the court finds there are disputed issues of fact, summary judgment is not warranted on count 4. So, here, a jury could reasonably conclude all right. I'd love to have an Instagram live about this. Negligence per se. We've still got 4 pages to go. As I said, I'm on a tight time schedule at the moment. So if I get this done, I might pop on after. But I just wanted to get this out here so that everybody has it all here. In determining whether a violation of statute constitutes negligence per se, a plaintiff must demonstrate that the breach of the statute harmed persons intended to be protected by the statute, and that harm suffered is the type of harm the legislator intended to prevent. Plaintiffs rest their negligence per se claim on the criminal defense defamation statute. And so there she outlines the statute. Okay, I'll just let you. So defendants argue that plaintiff's negligence per se claim must fail because the underlying statute was deemed unconstitutional in State versus Turner. Defendants are correct that Turner case held that the criminal defamation statute was unconstitutional because it was overbroad in that it failed to narrow the definition of criminal liability to only false statements. However, the statute was amended after the Turner case to reflect that the person communicating the false and defamatory matter must have knowledge that it is false, as the current version of the Minnesota statute has not been held to be unconstitutional. Plaintiffs can proceed with their negligence per se claim. Well, that's a bit embarrassing. They used an old argument. So she said defendants are correct. The current case held that the criminal defamation statute was unconstitutional because it was overbroad. However, it was amended. And it's the amendment that now counts. A jury could reasonably find that the plaintiffs are the type of persons intended to be protected by statute, as they claim Ms. Paulson's posts expose them to contempt and degradation in society, resulting in injury to their business. A reasonable jury could determine the legislature intended to prevent this type of behaviour by enacting this statute. So again, that summary judgment's been denied. Deceptive trade practices. A person engages in deceptive trade practices where in the course of business, vocation, or occupation, the person disparages goods, services, or business by false, misleading representation of fact. An action under Minnesota statute 1.8 to recover for a false or misleading statement or report differs significantly from the action for defamation where there is a presumption that the disparaging statement is false. The burden is on the plaintiff to prove that the statements are false. Defendants' statements regarding trafficking, forced labour, cult-like behaviour, and strict control and isolation of dancers could all be considered disparaging to 7M, Mr. Shin, and the Derricks. See, she hasn't said they are. Remember, she hasn't said they are. She's saying they could be. The resolution of this claim will rest on whether or not the jury finds the statements were false. So she's saying a reasonable jury could make this assumption. Okay, intentional interference with prospective advances. There are 5 elements to claim a tortious interference with prospective a business advantage. No, I haven't seen a statement as yet, and I haven't seen anyone. Hello, Mama Kay. I haven't seen anyone post that she's made a statement. So, essentially, to be fair, the judge is essentially just handballing it all to a jury, which is interesting. But that's okay. That's what she had to determine, whether there was a case where it could be solved by a jury. But as I said, we'll have to start a fundraising thing I'll have to start fundraising so I can go, hey. Just going to see if there is a if there is. I don't know if there's a date yet that's been set. Now, don't forget, she is in her right to appeal the decision. She can appeal this if she wants. She'd have to find where the judge has not interpreted the law correctly. She has to find but it could be appealed. There's nothing to stop her from appealing. By the way, no, there's no dates here yet. No, there's nothing on file that I can see for a date. Yeah, well, I keep looking too, but I haven't seen a reaction. Although it has been rain. Yeah, well, if I go, I'll come across to Canada. I may as well do the Learn a Lawyer World Tour, hey? Anyway, being sued is, well, yeah, wow. Remember, she's never lost a case. And the judges essentially just said this is going to, this has to go to a jury. This has to go to trial. I mean, we haven't even got to the point where we haven't even got to the question of whether she's a lawyer or not. A journalist or not. All right. So I've got 10 minutes left. So as I said, I might have to just step away for a moment and take a phone call, and then I'll be straight back. But I'll definitely let you know. So there are 5 elements to a claim of tortious interference with prospective business advantage: that the existence of a reasonable expectation of economic advantage, defendant's knowledge of that expectation of economic advantage, that defendant intentionally interfered with the plaintiff's reasonable expectation of economic advantage, and that the intentional interference is either independently tortious or in violation of a state or federal statute or regulation, that in the absence of a wrongful or act of defendant, it is reasonably probable that the plaintiff would have realized his economic advantage and benefit, and the plaintiff sustained damages. Mama Kay, how many years is this going to drag out? I'll be very surprised if this goes to trial this year. I reckon it will be next year, and it will drag on as long as you want it to drag on for. Because as I said, if she appeals, then you've got the whole appeal process to occur, and it is her right to appeal. By the way, she has that right. If you have an unfavorable decision, you can appeal. But that just extends out the court. I mean, my advice to her would be settle. My first advice would be to settle, and then but if she's hell bent on going to trial, then let's see if we can get this done as quickly as possible. But they have to go to court and argue over how many days they expect, how many days they want. So Frankel, So the plaintiff has the burden to demonstrate the existence of a reasonable expectation of economic advantage. And to that end, plaintiff must specifically identify a third party with whom the plaintiff had a reasonable probability of future economic relationship. Thus, a plaintiff projection or of future business with unidentified customers without more is insufficient as a matter of law. Reputation is insufficient to establish that an expectation of economic advantage was damaged. First, a jury could find that the plaintiffs had a reasonable probability of future economic relationships based on their previous contracts and sponsorships, and the fact that they had substantial number of followers. They specifically identify such current and potential clients as LA Clippers, Forever 21, and Matt Comet. Second, Paulson clearly knew, here we go, and this is where we get into the malice. She clearly knew about the plaintiff's economic expectations with these clients, as she would post about ongoing or potential relationships with the relationship plaintiffs had with other sponsors. Third, a jury could reasonably find that Ms. Paulson's intentionally interfered with these potential contracts, as indicated by her posts regarding Max Cosmetics and LA Clippers. Fourth, a jury could conclude that it is reasonably probable that the plaintiffs would have realized an economic advantage on these contracts based on their extensive social media presence and the history of significant earnings from branding. Shows you how. And fifth, plaintiffs stated that they have made less money every year since Ms. Paulson's postings than a year prior. A jury could reasonably determine that loss is a result of Ms. Paulson's intentional interference. So, and the other thing is, who's the person that got the financial advantage from this? She did. So the motion for summary judgment is denied. The motion for summary is granted with those statements because there was no links, okay? So it's not a win. And then it's denied. And then all discovery disputes shall be brought via separate motions. The Court will contact parties to schedule the next hearing in this matter. And that, my friends, is the document. I mean, the thing is, by dragging it out, it does drains everyone's pockets. That's why settlement, I mean, well, the judge had said that she had reviewed all that, she'd watched all the videos. So she had watched all the videos. Now, the other thing is because of some of those statements made by the judge, all her Blake Lively, all of her stuff that she's been, particularly about the stuff about the judge and all of this other stuff, everyone now, I mean, it is my view and my opinion that this judgment has actually destroyed her credibility, because who's going to believe somebody that has made statements that could be found? So, all right, well, as I said, I have to go. I have to take a phone call in a minute. Am I just waiting for the phone call? Well, and that's the thing. If 7M wins, I won't be surprised if she's bankrupt. I mean, that's the thing. And so obviously the reason why it's taken so long is the judge has had to watch everything and read everything, and some of those lives were pretty messy. So look, if there's any dates, I'll come back and let you know about them. But look, I want to thank you for being here. If you're on the replay crew, say hi. Please make sure you hit like and subscribe. Miss Balls is hilarious. This is what she's just posted on X. I'll just show you this before we go. She's just put it where she cried. Remember that? It is my hope that she has learnt that she learns from it and is a lot more careful about what she does the next time, but who knows? But I think, I mean, I would be pushing for my advice to her would be to settle, offer settlement, cut your losses, but I mean, it depends now whether they think it's too far gone. But it's not a win. It's not a win. So anyway, yes, as I said, I'd like to thank you all for watching. I have to head off now. As I said, I've got an important phone call I've got to take. Cry you bully, yes. And I will catch you next time. I might be on a bit later, and to see as we wait for the fallout to follow up on what's happening here. I'll catch you next time. Bye for now.